Second case this morning is also from Sedgwick County. It's 126-682, the state of Kansas versus David Bennett. Who we have here for the appellant?
May it please the court, Sean Randall of the Appellate Defender's Office on behalf of David Bennett, present ready for argument. Your honors, if I may request 3 minutes for rebuttal.
That is granted. And for the appellee?
May it please the court, Assistant District Attorney Matt Maloney for the state.
You may proceed.
Thank you, your honor. I think the case before this panel today is relatively straightforward, your honor, or your honors, I apologize. Both parties agree that the state and the district court received Mr. Bennett's properly filed request for disposition of detainers on August 29th, 2022. That means that pursuant to the interstate agreement on detainers, his case needed to be tried within 180 days, which would have resulted in a trial date of February 25th, 2023. Ultimately, his trial did not commence until April 10th, 2023. And then the question obviously before this court is whether good cause existed to continue his trial those extra 44 days. My colleague and I also agree that 35 days of continuances from October 3rd, 2022 to November 7th, 2022 were granted for good cause. The difference of opinion concerns those remaining 9 days. That would be the difference.
Well, before we start counting up the days and looking at good cause.
Yes.
How do you get around the Hill case of the United States Supreme Court?
A multitude of ways. I would state that I would at least concede perhaps that the New York v. Hill case cited by the state is at least perhaps instructive or something that this court can look at. But it is by no means controlling or authority that this court has to abide by. What we are examining in this case is a Kansas statute, KSA 224401. And the final arbiter of what Kansas statutes mean is the Kansas Supreme Court.
But the Kansas Supreme Court has said, since this is an interstate compact, we certainly look to other courts. And the biggest court up there is the United States Supreme Court.
That's correct. But our Kansas Supreme Court has interpreted provisions of the United States Constitution different than the Kansas Constitution. I mean, I think Hodes v. Nauser was one of the more recent cases where, irrespective of what the United States Supreme Court case, we found greater protections under the Kansas Constitution. And so what I would argue is that we have directives here from the Kansas Supreme Court that in speedy trial context, that a acquiescence is not enough to waive a defendant's speedy trial rights under the interstate agreement on detainers action.
But those are construing the Kansas speedy trial statute. They're not construing the interstate compact, correct?
That's correct. But I mean, the rights under the interstate agreement are speedy trial rights in, I think, in just a different format. We have a speedy trial statute. We have an interstate agreement on detainers statute. I think even New York v. Hill, if I may. I think it's cited in the state's brief, where it said that the New York v. Hill case eventually ended up before the United States Supreme Court, with the issue being whether defense attorney's agreement to a date beyond the 180-day limit waives a defendant's speedy trial rights under the agreement. So we do.
I guess just to wrap up my question, though, do you have any Kansas Supreme Court case saying acquiescence isn't sufficient that's construing 22-4401?
I do not have that in that specific context, but I think I do have it, and I cited it in my reply brief, State v. Queen, which was decided 4 years ago, as opposed to the United States Supreme Court of New York v. Hill, which was 26 years ago. And I think that case is instructive and very clear about what is required in order for a defendant to waive his rights under that statute. And it specifically, I think, indicated that defense counsel's statement confirming he was available for a trial on the specific date offered by the court did not cause a delay that happened as a result of the defendant. Such an agreement was not an affirmative action that prevented a speedy trial. And we have exactly that in this case. We have, hey, I know your trial schedule. Do you want May 2nd or you want May 8th or May 22nd? And the defense counsel says May 22nd. That was a specific trial date offered by the district court. And his mere acceptance or acquiescence to that date is not an affirmative action that would, I think, waive his rights under the Interstate Agreement on Detainers Action.
So counsel, I'm gonna give you a hint. They're looking at the trial schedule and the judge says, counsel, what do you have open this spring? And the defense attorney says, I'm not available in April, but I have some time in late May. Now, under that scenario, is the defense counsel more liable to acquiescence because he ignored April and went straight to?
It would make the argument certainly, I think, weaker. But
Okay.
I point to Queen because I mean it.
Well, I'm having another.
Sorry.
But in here, it was the district court judge who proposed the dates. How does that change anything in?
I think it makes it perhaps stronger. I mean, we don't have. I mean, I think Queen also makes it very clear that making sure that a client is tried within the time limit is a responsibility that falls upon state actors, whether that be the prosecutor or whether that be the district court judge. And, you know, I think the record is replete with the district court saying, you know, hey, look, not my fault. No one told me that, you know, I was supposed to.
Even though the files received from the clerk and this judge would have seen that in the court file.
Well, I think the district court said, I'm not, what am I expected to do? Look at a file before I arraign somebody? I mean, I might be, you know, paraphrasing, but it's pretty close to that. And when it's finally brought to his attention, oh, wait, maybe we do have a problem here. He says, look, not my fault. And I think Mr. Bennett aptly said, not mine either, whether it's yours or whether it's the prosecutor's. It's not on me to try me within the 180 days that I requested when I properly filed it, when I sent it to you, and it was received by August, you know, on August 29th, 2022.
Let me shift gears here.
Of course.
All right. The last 9 days that the court allowed the extension on because of the court's crowded schedule, he said it was impossible for me to do this any sooner. Why isn't that good cause?
Well, specifically, I think because you alluded to the problem that I would say is that the court is using or quoting, or at least not saying it directly, but that I've got a crowded docket. And a crowded docket exception exists in the speedy trial statute, and it's evidence that our legislature knows how to carve out an exception and use that language when we're talking about speedy trial. It doesn't appear anywhere in the Interstate Agreement on Detainers Action. If our legislature wanted to carve out an exception and say a crowded docket would be good cause, then they could have written it into the statute, because we have another statute where they did write that in, and they did say that. And if they didn't say it in this, I think by reading those two things and seeing that it exists in one statute, doesn't exist in this one, is evidence that that was never intended to apply in this case.
But the statute just says good cause. In the speedy trial statute, you look at who you're charging a continuance to, whether it's the state or the defense.
Correct.
Under the Detainer Act, it just says good cause. And whether the state asks for it or the defense asks for it, doesn't matter. And whether it's the court's reason, it would seem, doesn't matter. You just look, was there good cause for this? And
I would agree with everything that you indicated. You're right, that we don't have to talk about who made the request or who did it. It's just whether or not there was good cause, Your Honor. I would agree with all those points. My argument would be that the states or the district court's failure to take note of the 180 days when trial was initially set they can't come back later and say, oh, wait, never mind, my fault, good cause, I'm trying to move it up, I'm trying to comply with it, but I just can't do it. So now we get this post hoc, after the fact determination of good cause, to obviate or to relieve them of their mistake and their failure to do what needed to be done under the statute. I mean, Mr. Bennett did everything that he possibly can to get this case tried, and perhaps even more so. There was no need for him to be filing the motion to dismiss on his behalf to bring it to everybody's attention. To be frank, I wish he hadn't and had waited until after 180 days, but he didn't. He brought it to the court's attention and said, you're not going to try me within 180 days. Court says, oh, wait, maybe you're right. I'll move it up. I mean, moved it up a month and a half from when it was originally scheduled, but couldn't do it fast enough and said, I just can't do it. That's not good cause. At that point, it would allow the court to shirk its responsibility and then come back later and say, well, look, I did the best that I can, and I'm sorry I messed up all those times before. I'm sorry, Mr. Bennett, that you kept bringing it to my attention. I'm sorry that you ended up having to represent yourself, but look, I did everything that I possibly can. I think it would invite courts to claim their inability to set it on a docket to avoid their responsibilities under the statute. And I think the court, when it was originally setting it, indicated, at least implicitly, that it could have set this case and it could have tried it if it wanted to. When it said, hey, look, I know your schedules in March and April, so I'm proposing May. I think one could say, well, the reason why he indicated that is because if he had taken note and reviewed the file, like he probably should have when arraigning someone on felony charges, that he could have set a trial date within the March or the March or April timeframe and failed to do so.
No one even was discussing a deadline when they took those dates, is that right?
The state didn't bring it up, the court did not bring it up, and I don't believe that Mr. Bennett's attorney brought it up, which I think that led to Mr. Bennett being so disappointed with his counsel that he eventually, requested and ultimately proceeded pro se.
Mr. Randall, is there anything in the record of the state advising toward any time that this is a detainer act and needs to be tried within 180 days?
I think the first time that I think there were a few mentions of that at the very beginning of the case, prior to the preliminary hearing being set, when he was first brought in on his writ and things of that nature. I don't believe it was re-acknowledged or re-brought to the court's attention until it requested a hearing on March 3rd. March 3rd, they came and requested a hearing before the court, I think recognizing the timelines and saying, we need to figure out what these timelines are because we've got this detainer action. And I believe it's that same hearing when the court then says, well, hold on, why didn't anyone bring this to my attention? I can't be expected to, review a file every time I arraign somebody. And so I think there was a significant break. I think March 3rd probably would have been the first time that the state tried to bring it to the court's attention or re-advise the court of that fact.
You've used 12 minutes.
Oh, okay. Then I will say the remaining remarks for rebuttal unless the court has any further questions.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I do agree with what counsel said at the outset of the argument that this is a straightforward appeal. I would argue it's so straightforward because it is controlled by Hill. Now I'm going to start by reading language from Hill because part of the defense's argument is that this is a state law matter because it's a state statute and that this court can therefore ignore Hill. In Hill, the court said, as a congressionally sanctioned interstate compact, within the compact clause of the United States Constitution, the IAD is a federal law subject to federal construction. This is not a case where this court is being asked to look at a Kansas constitutional provision or a Kansas statute that is similar but somehow different from a federal law. Of course, in that context, Kansas courts are allowed to determine whether the Kansas statute or constitutional provision offers different or additional protection from a federal law. That is not this case. The Kansas law is exactly what the federal law is, and it's a law that 48 states have agreed to participate in.
You have a pin side from what you just read.
Yes, that is at 528 US at 111 in the Hill opinion. And so because this is a federal law subject to federal construction, our position is that Hill is not just instructive, it is dispositive and controlling. And Hill is so similar to this case, and I would argue that the only distinction really is actually harmful for the defendant in this case. In Hill, basically what happened was the parties were before the court to set the trial date, and the prosecutor basically said, "Judge, I think you'd already proposed such and such a date. That works for the state." And the court said, "Okay, defense counsel, how about you?" And the defense attorney more or less said, "Yeah, that's fine for me." Here, we have more than that. We have a situation where the court specifically scheduled this to accommodate defense counsel's schedule. The court was aware that the defense attorney was not going to be available at least through March because of his trial schedule. And so then he said, he then said, "Is that correct, Mr. Catfield?" And then basically gave 2 dates and said which of these 2 dates would work for you. And Mr. Catfield picked the latter of those 2 options. So I would argue that this was not, first of all, simply agreeing to under Hill is sufficient to defeat the defendant's claim. But here, I think we have even more than just agreeing to. We have a situation where the record clearly shows that the only reason that this case was set out until May was to accommodate the defense attorney's schedule.
I'm gonna interrupt you for a moment. In Hill, and help me out with Hill. In Hill, do the parties clearly hear the parties, including the court, not aware that this is a Detainer Act needs to be tried 180 days from the time the clerk receives this? In Hill, were the parties aware that it was a Detainer Act and therefore they can knowingly acquiesce?
I don't think the record showed that. The Hill opinion shows that they did. It seems like the first mention of the 180 days was well after the trial date was set. I think that it was after the defense had agreed to that date, and then at some point down the road, the defense filed a motion arguing that that time had passed. So I think in that way, it is not any different than in this case, where even if you could argue that maybe they weren't specifically aware of the 180-day deadline at the time that the trial date was set, I think that that's similar to what happened in Hill.
Can I ask you, if we follow your thought, and this is what we see in Hill, it's the state's responsibility, and that's why I keep on asking questions. It's their responsibility to bring the defendant to trial. The 180 days. They just have to be quiet. They don't have to say anything. And then when the district court sets something beyond the 180 days, they can let the defense walk right in that trap. Correct? Because isn't that what we're having here? I'm not saying there's any bad faith on anybody's part. My concern is the policy that we're moving one person's responsibility to another part.
Well, I think I understand Your Honor's point that yes, it is
It's just
right. Yes, that generally speaking, it is the state's obligation under normal speedy trial case law to get somebody to trial within the time frame. But I think that generally comes from case law interpreting the normal state speedy trial statute, and I think perhaps that's a distinction here within the IAD.
So you're saying the responsibility is on the court for these detainer acts, not the prosecutor? As a former prosecutor, I always saw it as my responsibility to get that person in that time, so I'm taking this from personal experience. But you're saying it's actually the court's responsibility?
Well, I think it's also the responsibility based on Hill and the federal case law. I think that the defense counsel certainly has a responsibility here, because we do know that even in a situation where it truly is just acquiescence to a date beyond the 180 days, that does toll the 180-day limit. And another citation and quote from Hill that I cite on page 7 of my brief is that Hill makes clear that scheduling matters, quote, are plainly among those matters for which agreement by counsel generally controls, as opposed to what the client might or might not want. And that makes perfect sense. And I know that that is a little bit at odds with, again, our general state statutory speedy trial analysis, but it does make perfect sense that an attorney obviously is in better position not only to know his or her calendar, but to know whether it's practical to be able to be prepared for a case on a date that's within those 180 days. And that's one thing that I've always found disappointing about our state speedy trial analysis, is to say, well, if a defendant wants to go, even if his attorney is saying, I can't possibly be ready to do a good job in this case, and it almost guarantees that I'm going to be ineffective if I'm forced to try it before I'm ready. Under our state statute, then yes, that does, generally speaking, the defendant's word carries the day. And so I think, to the extent I would argue that the way that this is analyzed under the IAD is what makes sense, a recognition of common sense, that the attorney should have the say when it comes to scheduling matters, because a defendant is not going to know the intricacies that require an attorney to get ready. But again, in this case, the situation is simply that Mr. Kepfield had other trials that were already set to go to court. And I cited the Waldrop case, which was a published opinion from this court back in 2011, because I think that does a good job of illustrating what does constitute good cause under the IAD. In that situation, one of the continuances was granted in part because the defense attorney needed additional time because he had been on vacation for a week and he needed more time to review discovery and talk to his client. So if a continuance that is necessitated by a defense attorney's personal life schedule constitutes good cause, I don't think there could be any credible argument that a continuance or a trial setting that is to accommodate Mr. Kepfield's trial and work schedule would not constitute good cause.
If Hill controls here, though, we don't even look at good cause, right?
Exactly, and I do think that Hill absolutely controls, and I think that this court in another 2011 case, this one unpublished, and I'm sure I'll probably butcher the pronunciation, at Beydler, B-E-Y-D-L-E-R, that I cited in the brief. This court held in that case that time elapsed during continuances requested by a defense counsel for scheduling reasons is not attributable to the state, and it does toll the time limit of the IAD. So again, I think the main argument that I've heard from the defense, both in their reply brief and today an argument to try to distinguish Hill, is just to say that we're really looking at the state statute here. But Hill clearly says that that's not the case. This is a federal law that is subject to federal construction, and we have a United States Supreme Court case that is directly on point. And again, I would point that the only distinction there is that in this case, it is very clear that the trial date was set specifically to accommodate defense counsel's schedule. And I think in the initial briefing of this case, the defendant himself acknowledged that the record does suggest and indicate that the trial court in this case would have been able to try the case before the 180 days passed, that it was only because he was aware of defense counsel's schedule that he set it beyond the 180 days. So Our position is that Hill controls and that this case is even more clear cut than Hill, and that the defendant's argument should therefore fail.
Thank you, counsel.
Thank you.
It appears as though the state continues to argue that Hill is controlling and that this is somehow a federal statute. I would note that in the Hill opinion, where it starts talking about a federal statute and that it's, you know, subject to federal construction, it's talking about basically preservation and how the case ended up in front of the Supreme Court and how they were able to address it. Mr. Bennett was not charged with violating USC whatever. He was charged in a Kansas district court with violating Kansas statute 224401. We can say it's a federal law. I'll concede that that the language is identical to a federal law, but that's not how Kansas statutes, which again, that's where this code is our legislature put it adopted it and put it in the revised statutes of Kansas. And that's not, the United States Supreme Court does not get to dictate how this court or courts of our state apply and interpret and analyze Kansas statutes.
When Bennett was released from prison, what state prison was he in when he was taken to Sedgwick County Jail?
He was in federal prison in the state of Arkansas.
So, in order for Arkansas to release him to come to Kansas, there has to be a uniform interstate compact like we have here that allows him to be released, right? So we're working within states, Arkansas, Kansas, correct? To move him from the federal prison to Sedgwick County.
I suppose so.
That's the Detainer Act. That's the whole point of the Detainer Act.
Yes,
We're going to release you, and that allows them to be tried within 180 days. So already you're working with two different states, correct?
correct.
So how can you say we should only be looking at Kansas when the mechanism to release them to come to Sedgwick County involves a separate state?
Because that mechanism that you're talking about is contained within the Kansas statute. That's where it has that says, hey, if there is a party state that is part of to this agreement,
Right.
then pursuant to this Kansas statute, you can bring him to the state of Kansas. So I mean, yes, there are other states, yes, there are other jurisdictions that are involved, but I would rely on the fact that what was Mr. Bennett charged with violating, and what provision did he use to file his interstate agreement on detainers, and all of those were Kansas statutes. And I think our court has made it abundantly clear that when a defense counsel confirms that they are available on a trial date on the specific date offered by the district court, that's not enough. That's exactly what happened in this case is, hey, I've got May 8th or May 22nd. Which one do you want? Those are specific dates. He chose one of those dates that the court offered him. That is not enough to waive his speedy trial rights under the interstate agreement on detainer actions, irrespective of what New York v. Hill says. And I'm not trying, and have never asked this court to ignore New York v. Hill. I recognize that the state law that the case law indicates that we can look at other interpretations of this statute as guidance, but we can also look to, or must look to, our Supreme Court's interpretation of what is required in order to waive those. And I think our Supreme Court spoke very clearly 5 years ago that just agreeing to a trial date that the court gives you and saying, okay, I'll choose that one, or that one works for me, or what have you, is not enough. I think it's also, It's frankly upsetting in the sense that to allow Mr. Ketfield to waive my client's rights or waive Mr. Bennett's rights without the record ever disclosing that he consulted with Mr. Bennett, that he asked Mr. Bennett, that Mr. Bennett was even allowed to say anything about whether or not you're okay with choosing this date outside your 180 days. I think Mr. Bennett made it abundantly clear that he was never going to agree to that. I think even when the judge said, hey, best I can do is 9 days after the deadline, he said, I'm not okay with that. I want it now. I want it within my 180 days. To allow his defense, his attorney to waive that without any kind of affirmative disclosure or statement or agreement from Mr. Bennett himself, I think again would fly in the face of the purpose behind the Detainers Act is so that the state must try him within 180 days. And they didn't do that in this case.
All right, counsel, thank you very much for your briefs and your arguments. They were excellent. You did a great job in this case. We will take a brief recess before taking up the final case this morning, probably just about 5 or 10 minutes.
All right.